Hello dear students, my name is Dr. Rashmi Nagpal, presently Dean at Geeta Institute of Law, that is in Karhans, Panipat, that is affiliated to Kurukshetra University. Topic for our discussion for today is lesson 33, the module on judicial independence for the subject constitutional law. When we talk about judicial independence, I think we need to know the introduction and the history behind judicial independence. Every democratic country, as we all know, adopts various means to ensure freedom of the judiciary and thereby to ensure individual freedom. The Constitution of India has provided for an independent and impartial judiciary in India, as it can only protect the rights of the individual and provide equal justice to all without any fear or favor. The USA has adopted a system of separation of powers to ensure independence of the judiciary, but in constitutional systems based on the concept of parliamentary sovereignty, the adoption of separation of powers is ruled out. This is the case in England. This is also partly the case in India. The doctrines of parliamentary and constitutional sovereignty are blended together in our country. Historical background of this independence of judiciary says that this concept took time to flourish in England. Earlier, the judges used to hold the position during the Crown's pleasure, and like any other servant, he could be dismissed by the king at his free will. Thus, the judges were subordinate to the executive. This subordination naturally led the judges favor the royal prerogative, since they were functioning at the will of the sovereign. The judicial independence was secured by the Act of Settlement 1701. This statute formally recognized the principles of security of judicial tenure by establishing that High Court judges and Lords Justice of Appeal hold office during good behavior. Appropriate and formal mechanisms had to be in place before a judge could be removed. Since the Act of Settlement, it has only been possible to remove a senior judge from office through an address to the Queen agreed to by both the houses of the Parliament. Need for the independence of the judiciary. 1. The basic need for the independence of judiciary rests upon the following points. 1. That is to check the functioning of the organs. Judiciary acts as a watchdog by ensuring that all the organs of the state function within their respective areas and according to the provisions of the Constitution. Judiciary acts as a guardian of the Constitution and also aids in securing the doctrine of separation of powers. 2. That interpreting the provisions of the Constitution, it was well known to the framers of the Constitution that in future the ambiguity may arise with the provision of the Constitution, so they ensured that the judiciary must be independent and self-competent to interpret the provision of the Constitution in such a way to clear the ambiguity, but such an interpretation must be unbiased, that is free from any pressure, any organs like executive. If the judiciary is not independent, the other organs may pressurize the judiciary to interpret the provision of the Constitution according to their will. Judiciary is given the job to interpret the Constitution according to constitutional philosophy and the constitutional norms. Number 3 is, why is the need for independence of the judiciary is that the disputes referred to the judiciary. It is expected of the judiciary to deliver judicial justice and not partial or committed justice. By committed justice, we mean to say that when a judge emphasizes on a particular aspect while giving justice and not considering all the aspects involved in a particular situation. Similarly, the judiciary is expected to act in an unbiased manner. The framers of the Indian Constitution at the time of framing of our Constitution were concerned about the kind of judiciary in our country. This concern of the members of the Constituent Assembly was responded to by Dr. B.R. Ambedkar in the following words: "There can be no difference of opinion in the House that our judiciary must be both independent of the executive and must also be competent in itself. And the question is how these two objects can be secured." The question that arises at first instance in our minds is that what made the framers of our Constitution to be so much concerned about providing the separate entity to the judiciary and making itself competent? The answer to this question lies in the very basic understanding that so as to secure the stability and prosperity of the society, the framers at that time understood that such a society could be created only by guaranteeing the fundamental rights and the independence of the judiciary to guard and enforce those fundamental rights. Also, in a country like India, the independence of judiciary is of utmost importance in upholding the pillars of the democratic system, hence ensuring a free society. It is well known fact that the independence of judiciary is the basic requisite for ensuring a free and fair society under rule of law. Rule of law that is responsible for good governance of the country can be secured through an unbiased judiciary. The doctrine of separation of powers, which was brought into existence to draw upon the boundaries for the functioning of all the three organs of the state, namely legislature, executive and judiciary, provides for a responsibility to the judiciary to act as a watchdog and to check whether the executive and the legislature are functioning within their limits under the Constitution and not interfering in each other's working. This task given to the judiciary to supervise the doctrine of separation of powers cannot be carried on in true spirit if the judiciary is not independent in itself. An independent judiciary supports the base of doctrine of separation of powers to a large extent. It is theoretically, though, very easy to say and to talk about the independence as far which the provisions are provided in our Constitution. But these provisions introduced by the framers of our Constitution can only initiate towards the independence. The major task lies in creating a favorable environment for the functioning of the judiciary, in which all other state organs function in cooperation so that independence of judiciary can be achieved practically. The independence of judiciary has also to be guarded against the changing economic, political and social economic scenario. Wherever there is a talk regarding the independence of judiciary, there is also talk of the restrictions that must be imposed upon the judiciary as an institution and on the individual judges that forms part of the judiciary in order to ensure smooth functioning of the system. There must be a right blend of the two. Then what is the meaning? The meaning of independence of judiciary is still not clear after years of existence. Our Constitution, by way of the provision, just talks of the independence of the judiciary, but is in nowhere defined what actually is independence. The primary talk on the independence of judiciary is based upon the doctrine of separation of powers, which talks of the independence of judiciary as an institution from the executive and legislature. The principle of independence of judiciary has been laid down in various human rights instruments, including the Universal Declaration of Human Rights, Article 10, International Covenant on Civil and Political Rights, that is Article 14. There are also a number of UN standards and European framework which talks about independence. The other meaning of judicial independence can be found out by looking at the writings of the scholars who have researched on the topic. Scholars say independence of the judiciary is the independence of the exercise of the functions by the judges in an unbiased manner that is free from any external factor. So, this can be understood as the independence of the institution of the judiciary and also the independence of the judges, which form the part of judicial system. The components, when we talk about the components of judicial system, judicial independence, the components as talked of here refers to some of the requisite terms and conditions which are so necessary that if they are absent, the independence of judiciary cannot exist. It is very difficult to lay down certain set conditions as law is dynamic in itself and of the changing economic, political and social scenarios. Despite that, the Indian Constitution has provided for components which could be responsible for ensuring independence. We have certain constitutional provisions with regard to this. They are: one, that is security of tenure, salaries and allowances, powers and jurisdiction of the Supreme Court, no discussion on the conduct of judges in state legislature or the parliament, separation of the judiciary from the executive and power to punish for contempt. We start with the first one, that is security of tenure. The judges of the Supreme Court and High Courts have been given the security of tenure. Once appointed, they continue to remain in office till the age of retirement, which is 65 years in case of Supreme Court judges and 62 in case of High Court. The provision regarding this is provided in Article 124, Clause 2 of the Supreme Court relating to Supreme Court and Article 217, Clause 1 of the High Court relating to High Court judges. They cannot be removed from the office except by an order of the President, and that too on ground of proven misbehavior or incapacity. A resolution has to be accepted to that effect by a majority of total membership of each House of Parliament and also by a majority of no less than 2/3 of the members of the House present and voting. The procedure is so complicated that there has been no case of removal of a judge of a Supreme Court or High Court under this provision. Next aspect that deals with the independence is the salaries and allowances. The salaries and allowances of the judges is also a major factor which makes the judges independent, as their salaries and allowances are fixed and are not subject to the vote of legislature. They are charged on the Consolidated Fund of India in case of Supreme Court judges and the Consolidated Fund of State in case of High Court judges. Their emoluments cannot be altered to their disadvantage except in the event of grave financial emergency. The provision for this regard is in Article 125, Clause 2. Powers and jurisdiction of the Supreme Court further ensure that the judiciary is independent. Parliament can only add to the powers and jurisdiction of the Supreme Court, but cannot curtail them. In the civil cases, the Parliament may change the pecuniary limit for the appeals to the Supreme Court. Parliament may also enhance the appellate jurisdiction of the Supreme Court. It may confer the supplementary powers on the Supreme Court to enable it work more effectively, and it may confer power to issue directions, orders or writs for any purpose other than those mentioned in Article 32. The powers of the Supreme Court cannot be taken away, so that the independence of the judiciary is ensured. An important aspect for independence of judiciary and the judicial system is that no discussion on conduct of judge in a state legislature or parliament. The relevant provision is in Article 211, provides that there shall be no discussion in the legislature of the state with respect to the conduct of any judge of the Supreme Court or of a High Court in the discharge of his duties. A similar provision is made in Article 121 of the Constitution, which lays down that no discussion shall take place in Parliament with respect to the conduct of a judge of a Supreme Court or High Court in the discharge of his duties, except upon a motion for presenting an address to the President praying for the removal of the judge. The power to punish for the contempt of Supreme Court and High Court further go a long way in ensuring that we ensure the independence of judiciary. Article 129 provides the Supreme Court shall have the power to punish for contempt of itself. Likewise, Article 215 lays down that every High Court shall have the power for the contempt of itself. Thereby, both the Supreme Court and the High Courts have the power to punish any person for their contempt. Another important aspect is the separation of judiciary from the executive. Article 50 contains one of the directive principles of state policy and lays down that the state shall take steps to separate the judiciary from the executive in the public services of the state. The object behind the directive principle is to secure the independence of the judiciary from the executive. Article 50 says that there shall be a separate judicial service free from executive control, which shall ensure that the judiciary is independent. The independence of the judiciary, as is clear from the above discussion, hold a prominent position as far as this institution is concerned. It is clear from the historical overview that judicial independence has faced many obstacles in the past, specifically in relation to the appointment and transfer of judges. Courts have always tried to uphold the independence of the judiciary and have always said that independence of judiciary is the basic feature of the Constitution. Courts have said so because the independence of judiciary is the prerequisite for the smooth functioning of the Constitution and for a realization of a democratic society based upon the rule of law. The landmark cases dealing with the independence of judiciary. The question of transfer of a judge from one high court to another has raised many controversies from time to time. During the emergency of 1975, 16 high court judges were transferred from one high court to another. In the words of Justice Bhagwati, what was held by the courts was that the transfer of the high court judges during the emergency were made not for the purpose of furthering the cause of national integration, but that was by way of punishment. As the phraseology of Article 222 clause 1 stands, neither the consent of the judge is necessary to his transfer, nor is the opinion of the Chief Justice binding on the government. This is S.P. Gupta versus Union of India, 1982 Supreme Court case. In this case, unanimously agreed with the meaning of the word consultation as determined in the Union of India versus Sankal Chand Himmat Lal Seth. It further held that the only ground on which the decision of the government can be challenged is that it is based upon mala fide and irrelevant considerations. In doing so, it substantially reduced its own power in appointing the judges and gave control to the executive. The matter was raised again in the case of Supreme Court Advocates on Record Association versus the Union of India, which is popularly known as Judges Transfer Case 2. In this case, the Supreme Court overruled the decision given in S.P. Gupta versus Union of India and held that in the matter of appointment of judges of High Court and Supreme Court, the Chief Justice should have the primacy and the appointment of the Chief Justice should be based upon seniority. It further held that the Chief Justice must consult his two senior most judges and the recommendation must be made only if there is a consensus among them. Referring to the third case, which is popularly known as Judges Transfer Case 3, a controversy arose when the Chief Justice recommended the names for appointment without consulting with other judges in the year 1999. The President sought advice from the Supreme Court, that is popularly known as re-presidential reference, and a 9-member bench held that an advice given by the Chief Justice without proper consultation with other judges is not binding on the government. As of now, due to the decision in Judges Transfer Case 2, the appointment of judges in High Court and Supreme Court are fairly free from executive control, an important factor that ensures the independence. The following are the other provisions that work towards the same goal. The decision of the judge's case could never have been intended by the framers of the Constitution, as they always set the task of keeping judiciary free from executive and making it self-competent. The decision of the second judge's case and the third judge's case is praiseworthy step by the court in this regard. If we talk about the most recent developments in this case, the Lok Sabha has recently passed the Constitution 121st Amendment Bill 2014 and the National Judicial Appointments Commission, which is popularly known as NJAC Bill 2014. These bills seeks to facilitate setting up of a commission for the appointment of judges, replacing the 20 years old collegium system, which had been under severe criticism. While the Constitution 121st Amendment Bill 2014 seeks to put the proposed commission and its entire composition in the Constitution, the other legislation lays down the procedure to be followed by the proposed body for appointment of Supreme Court judges and the transfer and appointment of Chief Justices and other judges of the High Court. This bill of recent origin goes a long way ensuring the independence and integrity of the judiciary. As per the proposal, Chief Justice of India will head the National Judicial Appointment Commission. Besides the Chief Justice of India, the judiciary would be represented by 2 senior judges of the Supreme Court, 2 eminent personalities, and the law minister will be the other members of the proposed body, making it a number total of 6. Further, to ensure the independence of judiciary and to allay the fears, the composition of the commission has been given constitutional status. Constitutional status would ensure that any future government does not weaken the composition through an ordinary legislation. Coming to what is collegium system, that has for long worked in India and finds no place in Indian Constitution. It is a system under which the appointments and transfers of judges are decided by a forum of the Chief Justice of India and the 4 senior most judges of Supreme Court. As discussed earlier, this kind of a system finds no place in our Indian Constitution. This system of collegium has its genesis in a series of 3 judgments, which is now clubbed as the 3 judges cases on appointment of judges, as have been discussed in this lesson. The new bill is an attempt to scrap this collegium system of appointment of judges, which is not appropriate, and thereby now proposes a new mechanism under National Judicial Appointment Commission, thereby ensuring the independence of judiciary. When we talk about the independence of judiciary, we must know certain facts, that the judges have the ultimate responsibility for decisions regarding freedoms, rights, and duties of natural and legal persons within their jurisdiction. The independence of each individual judge safeguards every person's right to have their case decided solely on the basis of law, the evidence and the facts, without any improper influence. A well-functioning, efficient and independent judiciary is an essential requirement for a fair, consistent and neutral administration of justice. Consequently, judicial independence is an indispensable element of the right to due process, the rule of law and the democracy. Coming to the conclusion of this discussion that we had on the independence of judiciary, we have learned that the recent developments, scrapping of collegium system, passing of the two bills, National Judicial Appointment Commission Bill, is an important step towards ensuring the independence. Apart from the constitutional provisions of the security of tenure, that their conduct is not to be discussed in the state legislature or the parliament, their salaries are not open to be reduced during their tenure except in case of grave financial emergencies, and such like provisions which ensure that the constitution aims to ensure the dignity of the judges. The judicial system comprises of, it's an institution which comprises of the judges of the high courts and the Supreme Court, and scrapping of collegium system and the introduction of the new bill shall go a long way ensuring the independence. And wherever do we find a mention of the independence of judiciary, there is always a concern about the latent dangers of the judicial independence, and there arises the importance of judicial accountability. Accountability is all important for the smooth functioning of any institution. The recent development in this regard is, as we have discussed, recommendation of the Law Commission for the inclusion of a whistleblower provision, which is aimed at protecting those making complaints against judges, in a draft bill dealing with the removal of judges of the Supreme Court and High Courts. Introduction of such a bill by the Law Commission will be a major step in the direction of making changes to the rigid procedure in our constitution, which is relating to the removal of judges of the Supreme Court and of the High Courts. So the discussion culminates with that all the provisions, be it in the constitution and be the later developments, have a vision to ensure that the judges of the high courts and Supreme Courts are free from any external pressure, but judicial independence and judicial accountability must go hand in hand for a fair distribution of justice to all the citizens of India. Thank you.